That's an excellent question. We don't use that in the guilt-innocence phase. It's not appropriate for guilt-innocence at this juncture, although I'm actively exploring constitutional challenges to criminal law itself, the very paradigm of crime and punishment. Every time you open up your news feed, and especially if you read medical journals, you find some new thing we've learned about the brain. Just today, I found that they've identified some 15 genetic markers for depression. So these are things that really matter because they really affect people. And people with depressive illnesses are not necessarily criminals, but a lot of people who I have represented over the years have had depressive illnesses. So the better the treatment, the better the outcome long term. But in terms of guilt innocence, we don't use that at all. We use it strictly for damage control because Florida, like many states, has a set of mitigating factors when someone is being sentenced. Now, you may think of it like a defense because I use it in negotiations. If I'm trying to get a negotiated dismissal on, say, a first offense assault charge, and there's a very aggravated fact pattern for some reason, and this particular second-degree misdemeanor is one where on a first offense, the state is looking for 60 days in jail. That doesn't happen too often, but it does happen. We would use that in negotiations or alternatively sentencing. If it's successful in negotiations, you can think of it as a defense because it results in a negotiated dismissal. Now, under that type of a fact pattern, it would be a negotiated dismissal where we would create our own diversion program. We would have our own set of treatment parameters. And this is the beauty of having a negotiated dismissal instead of the generic garbagey diversion programs that we have. We can actually solve the problem of crime one person at a time, and we can also use brain imaging for negotiated dismissal in many cases where people don't qualify it. The military officer I referenced earlier, he so did not qualify for a diversion program of any kind, and certainly not a negotiated dismissal. However, once we were able to show the state the images of what that man's brain looked like after deployment, you could see it in the prosecutor's face, an entirely different way of thinking about this individual. It was as if the person went from being a case number who needed punishment to, oh my God, no wonder. You could see the change in the prosecutor's face. I was sitting right there when we presented it. So brain imaging is technically not something we use as a defense. It's a damage control mechanism, but it can operate as a defense if we're able to negotiate a dismissal.
For a free phone consultation, contact attorney Stephen Cobb in Florida at 850-466-1522 or visit his website at www.cobblawfirm.com.